I was, the purpose of this meeting is to discuss some updates with reference to what's happening in the US immigration world. As we know, every day something new happens nowadays. So we're going to be talking about the H1B registration process. What is new in the H1B registration process this year? We will talk about the 100,000 new rule for H1Bs and how it affects employers. We will also discuss, recently there's been a visa bulletin update. We'll discuss that as well because it's been quite significant. For those waiting for green cards, you know that there is a long wait for Indian nationals for green cards, employment-based. So we'll discuss briefly about that as well. And then we'll talk about options other than the H1 for employers to hire talent from India. And we'll also talk about Indian entrepreneurs, what is the best way for them to come to the US. So let's start the session. And then, of course, at the end, Shika will take questions. You will, and we'll have a Q&A session. So with that, let's start. This is just about me. Okay, immigration updates. First, as I said, I wanted to talk about the March visa bulletin. The visa bulletin is something that you look at in order to decide whether you can file your green card or not. The long wait for the green card is because of the unavailability of priority dates. And the visa bulletin tells you what the priority date is currently. And if you have reached that priority date, then you're allowed to file your green card. So, and then for employment-based cases, there's a wait of, they're, I think, working on 2013 cases right now. So there's a long wait. But in March, we saw a strong forward movement for many visa categories. I thought it's worthwhile mentioning that. Let's talk about that. For family-sponsored cases, for family-based cases, we didn't see much forward movement. But for employment-based cases, EB1 is extraordinary ability one. That is for people who are on an L1, extraordinary ability. India advanced by 4 months for dates for filing chart. Now there are two filing charts. One is dates for filing, one is final action date. The dates for filing chart allows you to file your green card in advance because USCIS takes time to process the case. So they hope that by the time they finish processing the case, your priority date would have reached. So they allow you to file in advance. So that date for filing chart, which can be used in the month of March, it cannot be used every month, but they decided that we can use it in March. So that's a big advantage. And also the dates for filing for EB1 has been moving. It moved in October, moved in November, moved in December, and then again in March now, it's moved by 4 months. So that's pretty significant. It's the middle of the fiscal year for us because it's from October to October, and we are in March. So the movement in the middle of the fiscal year is quite unique. So EB1 moved by 4 months. EB2, which is what most Indian nationals file based on everybody with a master's degree files based on EB2, that moved by 11 months. That is pretty significant. EB2 has not moved at all of last year, hardly. There's been any movement. The final action date table is another chart that is used, and that determines your actual priority date. Meaning, if this date is reached, then you can, get your green card. EB1 in that category moved by 1 month, and EB2 worldwide moved by 6.5 months, and India moved by 2 months. EB3 final action date worldwide moved by 4 months, and Philippines moved by 2 months. EB4 is religious workers. So there's significant movement, as you can see. Predictions for the next visa bulletin. Every month there's a visa bulletin that comes out, and we predict that for the April visa bulletin, I don't think we'll see this much movement. Maybe there'll be some slight forward movement. I don't expect to see any retrogression, meaning any backward movement. So that's good news. That's for the visa bulletin. Let's now talk about the 100,000 fee. What is this 100,000 that everybody's talking about? And who does it apply to? So on September 19 of last year, the White House issued a presidential proclamation. This is not the way that law is supposed to be written, but it is just a proclamation. But it took effect and it was litigated. But since the proclamation is based on a travel ban, and since there's precedent about travel ban, even last uh, term that the same president was there, the courts decided that the president is allowed to impose a travel ban, and because he's based this on that same travel ban, the courts had to uphold their same decision from previously. So even though it was litigated, we still have this because of that. So the proclamation was issued on September 2025, and it is so as of now will remain in place for 12 months until September 2026. Under the proclamation, US employers that want to bring anyone new from outside the country, so say I'm a US employer and I want to petition for someone from India who's never been in the US so far, then for those people there is 100,000 fee. And if you file the petition, you'll get a request for further evidence. It could be either from USCIS, or if you're at the visa stage, then it could be from the Department of State. There are some exceptions to this policy. Some cases deemed in the national interest for people whose entry does not pose any threat to US security or welfare. So some deserving people, some people who are extraordinary maybe fall into the extraordinary category, or it's a case by case exception, or maybe healthcare workers, people working on research. USCIS is going to determine who is exempted from this law. Excuse me. In addition, the administration has directed agencies to also revise the wage rules. So the proclamation has two things: 100,000 fee as well as revision of the wage rules. We've seen some effect of that in the new H1B registration system, but we haven't seen anything with reference to increasing the actual wages. But let's see. I think that they will do that more subtly. Because the prevailing wages, we've seen some increase as of last year, but they have made no announcement about it. But we've seen some subtle increases there also. So as I said, the 100K rule is based on 212F of the Immigration Act and 215A. So 212 Act is the travel ban. And the reason for the proclamation is that the administration argues that there's an influx of lower wage workers that are threatening US jobs, especially in science and technology. We know for a fact that that is not true. That is not what research shows. It shows that, in fact, immigrants help bolster the economy, and the immigrants actually create jobs. But such is the rhetoric right now. So supporters of the policy, as I said, they say that they're protecting US workers by reducing competition from lower cost labor. So it is not lower cost labor, because the prevailing wages, let me tell you, for H1Bs is often higher than the wages offered to US citizens. Now, I understand that there is misuse of the H1B. There's always misuse. Whenever there's a law, there'll always be some amount of misuse of it. But the law itself is very strong, and there are a lot of checks and balances into the law, which curbs this misuse. And if you look at it, 80% of it is being used legitimately. Yes, there is some amount, but that doesn't mean that the law itself is wrong and the law should be removed. If H1Bs are removed, then this would hurt US innovation and business growth, especially in those industries like the tech industry and the healthcare industry that rely heavily on talent from outside the country. As I said, there have been legal challenges to the proclamation. However, so far, the legal challenges have not been successful. So let's see who's subject to this 100,000 payment and who is not. So any new H1B petitions filed after September 2025 for the beneficiary who's outside the US and does not have a valid H1B visa, for them, this is directly covered by the proclamation. Also, petitions filed on or after September 2025, where we are requesting consular processing. For example, if you file today a change of consular processing for F1 instead of filing a change of status, F1 is a student or a person who's in the country, or it could be a H4 dependent, it could be a student. If we are asking for consular processing, then of course that's covered by the proclamation. So they will be subject to the 100,000 fee. So we should not ask for consular processing in our cases. We should ask for a change of status. Third scenario where the 100,000 proclamation is applicable is when you file an extension or an amendment, but USCIS denies it and approves the case only for consular processing because they determine that the person is not in status and they cannot change or extend the status. Then also the 100,000 fee applies. So those are the three scenarios in which it applies. In which it doesn't apply if you're filing a H1. If you file a H1 before 2025 and you're going for a visa now, it doesn't apply. If you previously filed a H1 and now you're simply filing an extension or an amendment and you're in the US, it doesn't apply to those people also. Or you previously had a H1 and now you're just going for a visa to the Department of State. It doesn't apply to those people as well. Okay, so this is the table of who it applies to and who it doesn't. Now let's talk about the H1B registrations and what's happening there. As we know, the H1B registration for this year is starting in March, on March 4th and ending on the 20th. Let's first backtrack and see what this registration is, what H1B cap is. So every year there is a cap on the number of H1Bs that can be issued. It's an annual quota, and this quota is 65,000 for regular H1s and 20,000 for people who have a US master's degree. So totally we have an annual cap of 85,000. And because the supply is always much greater than the demand, you have 3 times the amount of people filing. They have done what is called a H1B registration process. What is this registration process? This is a lottery. It's a random lottery process. And in order to enter into the process, you have to fill out a registration form. So that's what the registration process is. And this has been happening for a few years, the registration process. But it always used to be random, as I just mentioned. But what has changed this year? It's not going to be purely random anymore. Weight is going to be given to applicants who have a higher prevailing wage or use a higher prevailing wage or a higher wage level. Wage levels, usually as per the Department of Labor, are 4 wage levels, level 1 to level 4. So if you offer your employee wage level 4, you're more likely, you're 60% more likely to get picked in the lottery when compared to a wage level 1. Okay, so that's the change in the registration process this year. Why is it changed? Again, the government's goal is to prioritize higher paid roles. I don't think it's high skilled, because anyone who's paid more, no matter what their skills, you will get a better shot. They don't want a random lottery anymore. They want to reduce level 1 filings. So if you have a wage level 1, for example, entry-level positions, entry-level jobs, such as students, F1s moving to a H1, they'll be impacted. So now the registration requires a preliminary wage analysis before we can file a registration. You have to look at the SOC code or the classification that needs to be used, the work location for that particular job classification, job title, and work location. What is the offered salary? What is the salary you're offering? And which wage level does it come under? So all this has to be determined before you actually file your lottery registration. And this is the information that you need to enter in your registration application for the employer and for the beneficiary. This hasn't changed from the previous years. This has changed. New information that you need to enter is the salary amount, whether it's per year or hourly, the prevailing wage, and the basis for the compensation. So what wage survey did you use? Did you use the Department of Labor wage survey? Did you use a private wage survey? And these are the prevailing wage levels. As I was telling you, level 1 to level 4. Based on Department of Labor, they have 4 levels. Level 1 is entry level. Level 2 is people who are more qualified. Level 3 is more experienced, and level 4 is expert. So depending on the number of years of experience, for example, a bachelor's with no experience, if the job requires a bachelor's and no experience, or bachelor's plus until 2 years of experience, you can give a level 1. After that, anything else would be level 2. If it's 3 years of experience, or if you have some added skill sets to the job, then it may fall into a level 2 category. If you're asking for a master's degree, it could fall into a level 3 category. If you're asking for a bachelor's plus 5 years of experience or 10 years of experience, it can fall into a level 4 category, just to give you an example. So people who are offering level 4 salaries will get a much better chance of getting picked in the lottery. Having said that, this year the lottery is going to be a little different. As we discussed, the 100,000 rule is going to play into the H1B lottery. A lot of companies such as TCS, Wipro, they file thousands of registrations. And this time they will not be filing because they will not be able to pay 100,000 fee for new H1Bs. And they are the ones that drive the H1B registration, most of it, because they file thousands pretty much registrations. So if they will not file this year, then of course the chance for people who are in the country to get into the lottery is higher. So there's always a silver lining. That's a silver lining. People who are in the country, students, dependents, H4s, they have a better chance of getting in. Okay, but of course, your chances of getting in depends on how many registrations are finally filed, and we don't know that number yet. As I said, how does this registration system work? Level 4, highest probability of getting in, and level 1, lowest probability of getting in. Now, the work location matters for the registration because the prevailing wage varies based on geography. So, for example, if your work is located in California, then the prevailing wage for California is much higher than the prevailing wage for Ohio, for example. And also, if your work is located in a city like New York City, obviously the prevailing wage is higher in New York City when compared to some rural area, right? So I know people will try to game the system, especially remote jobs, where they might move to a remote area and file their registration from there if they're working from home, because the work location determines the prevailing wage. Okay, so that's important. Of course, the job also determines the prevailing wage. A software developer, for example, will have a higher prevailing wage when compared to a computer programmer. People might again try to game the system by saying they're working as a computer programmer when they're working as a developer. But if you have an incorrect classification, for example, if your job duties say something and then your job duties say that you're working as a software developer, but you use the code of a computer programmer to get a lower prevailing wage so that you can pay level 4, because level 4 of a computer programmer will be equivalent to level 1 of a software developer, right? So if you try to game the system that way, I think you will get an RFE, a request for further evidence, and they will scrutinize the case more. So be careful. So as I said, what is critical this year for the registrations is check the wage levels, job classification, the work site, and the salary. All these four things are very critical in order to get into the lottery or improve your chances to get into the lottery. And any discrepancies, for example, if you put this information and then there's a discrepancy in the actual I-129 petition, when you put it, you have to follow the same wage level, same job. If you put something else, then again, there'll be a request for further evidence and most probably a denial. As of now, the registration system is still data only. You have to fill out information. There is no documents that need to be submitted, no LCA that has to be filed, no other supporting documents, no degree transcripts, job description doesn't have to be given. You don't have to show proof of work or proof that you can pay as an employer. So that nothing has changed there. Of course, they will, once you get picked, they will look at everything. And if they see that you filed a faulty registration, then they will deny it. Timeline for the registration, March 4th, ending March 20th. Date for filing is within 90 days, so you have to file by June 30th. And the start date of all H1s is October 1st. That's when the fiscal year starts. So you're filing in advance. Who is affected by this change? Entry-level people, staffing companies who hire students because they usually pay level 1 for entry-level positions. Students are affected, of course, because they don't have experience. Obviously, they fall under the entry-level category. Who benefits? People who get higher salaries benefit. People who are offered level 4 salaries will definitely benefit. What are the strategies that you need to follow for employer if you're an employer? Conduct early wage analysis. Look at the candidates that you have to file this year. Do a wage analysis for them. Determine by looking at their job title, see what best job title you can give them, what SOC code they come under. Review your compensation structure to see if you can pay them more without causing any discrepancies. Because if you pay a H1B person more than a US citizen for the same job, again, you have an issue. So if you're paying them more, there has to be a reason as to why you're paying them more, right? Like they have a special skill set or they have more experience. So you have to look at your compensation structure and see how they fit in there. And then once you've determined what pay you can give them, you have to then go to the Labor Department website and look at the prevailing wages and see which wage level they come under. Decide which work location you want to put them in, and prepare all the supporting documents in advance. For example, if you're giving someone a level 4 salary who's a student or who's just passed out, then prepare documentation in advance as to how you came up with that salary, because there might be an RFE otherwise. Common pitfalls that you should avoid as an employer. If you're using incorrect wage levels, please keep that in mind, that you don't misclassify an occupation, use the right codes, because the code, it's something called an SOC code, and that's what determines the wages. Job title, SOC code, and then geographic location. Make sure that if there's some information that you put in the registration, the same information is put in your petition if your registration is picked. Inconsistencies will lead to denials. Duplicate filings by related entities will not happen anymore. Just to give you background, last year H1B registrations, they made it a beneficiary-centric system, meaning that no matter how many registrations, how many employers file for registration for a single beneficiary, the beneficiary will only get one entry into the lottery. So that kind of takes away the incentive for employers to do duplicate registrations. So earlier, related employers were doing registrations for the same candidate to improve their chances of getting picked. Now that is not doesn't make any sense to do that. However, if you're not a related entity, two employers can still file registration for a single beneficiary, as long as the entities are not related. But if it's related, please avoid a duplicate registration, because there's no meaning in doing that anymore, and the registration will be denied. H1 will be denied even if it's not. The registration is not denied. Avoid last-minute preparation. Last-minute preparation will lead to mistakes. So do everything well in advance. Start the process on March 4th, and you have 20 days to complete the process. So make sure that you fill in all the information correctly. Now let's talk about, we are done with the immigration updates. Let's talk about what alternatives you have. Now the H1B is starting, the registrations will be done. A lot of H1Bs registrations won't be picked. Generally, it's about from 25 to 35% is the pick rate. We don't know this year because of that 100,000 rule. That might change, but generally that's what the pick rate. So employers should look into alternatives, alternative work visas available to the H1B. So if you are a US employer and you want to hire employees from India, say, this is what you need to look at. And if they're not picked in the H1, and there's some options which are better than the H1, honestly. So let's look at what those options are. L1 comes on the top of the list. So if you have a company in the US and you have a company in India, you can transfer your executives, managers, specialized knowledge people from your Indian entity to your US entity. There's no annual cap for this. There's no prevailing wage. There's no registration process. So it's quite a good option. And more importantly, if they're working as an executive or a manager, then they qualify for EB1, which is the best way of getting a green card, because the EB1 category is the fastest way of getting a green card for Indian nationals. So L1 is the best option if you have the setup, that is. Meaning you have a US company, you have an Indian company, and there's a relationship between both the companies. That is a relationship of a affiliate, parent, or subsidiary. Parent or subsidiary means that one company owns a majority stake in the other company or owns the other company completely. That's the parent and subsidiary relationship. And the affiliate means that there is one company that owns both the companies, or one individual that owns both the companies, the Indian company and the US company. That's the affiliate. So one of the two has to exist. Sorry. Okay. Even if you have a new office in the US, meaning you're establishing a new business, there is a different set of rules for new offices or startups. And you do not have to show that you have filed taxes. You don't have to show that you have a certain amount of business existing. You don't have to show a certain amount of money in the bank, except for maybe some startup capital that you need for about 6 months or so. You'll have to show a business plan as to what your plans are, what your marketing strategy is. You have to show that you have an office space and you've opened a bank account, but pretty much that's about it. You have to show what your staff is going to be in the future. That would be part of your business plan. So a key element for the L1s is mostly is how many people will the L1 employee or owner supervise. So L1 can be used for owners, if you are owner of your company, as well as employees. And we'll talk about owners a little later. But you have to show the number of employees is important, because you have to show that they're supervising at least 2 levels of employees, right? So if it's a business that doesn't have many employees or doesn't need many employees, may not be a good fit for L1. The more employees you need and the more chain of command there is, a bigger org chart, it's easier for an L1. Okay. Next is the O1, that's the Extraordinary Ability Visa. This can also work for entrepreneurs, so business owners as well as employees. So let's talk about the employees part. So if you want to hire an individual who has extraordinary achievement, who has done extraordinary achievement in business or the sciences, arts, education, or athlete. So for example, in the tech field, this can be used if there is a person who has extraordinary achievement in, say, AI. If they have written papers, they have a PhD, they've done research, and you can show how that research is useful for your company and for the US market, that's an ideal candidate for an O1. What are the documents you have to submit? Evidence of awards, patents, publications, media recognition. Now, you don't have to win the Nobel Prize to get an O1. You only have to show extraordinary achievement. Advantage of O1 is there's dependent visa, just like the H4. There's O2, dependent visa for children as well as spouses. There's no cap. There's no expiry period. This is renewed. Can you renew it indefinitely? And flexible employment, you can transfer from one employer to the other. And of course, the cap exempt H1. So you can file a H1 without having to worry about registrations if you are working for a university, nonprofit research organization, or a government research organization. Or if you are a company that is affiliated to a university. For example, if you are a hospital and you have an affiliation with a college, so it's like a teaching hospital where residencies are conducted. So that's a good example of affiliation to a university. For these, also say you are an IT company and you have an end client who's a university or a nonprofit research organization or a government research organization. Then also you're cap exempt. You can file year round. There's no lottery. So partnering with a cap exempt institution can be very strategic. Also, another way of getting around the cap is if you are working for a university or a cap exempt organization part-time, you can concurrently file a cap exempt H1. You can file a regular H1 as long as it's a concurrent filing, which means that you're doing two jobs. So say you're working for the university for over the weekends for 5 hours a week. The rest of the time you can work on a regular H1. So that's another key thing that a lot of people don't know. J1s, of course, if you are working as a trainer in an internship for training, research, academic exchange programs, J1 is an exchange program. This is mostly used by doctors and nurses sometimes. The J1 category, most of the categories, especially the ones used by doctors, require a 2-year home residency, which means that you can work on a J1, but you cannot change status or file for a green card on a J1. You have to leave the country, go back for 2 years, and then you'll be eligible to come back to the US. So that's the limitation on a J1. B1, visitor's visa, people coming for short-term meetings, you can send your employees to negotiate, to train, do market research. These people cannot receive a US salary. They cannot actually work in the US, but these are some of the activities that they can do. Now, there's some country-specific visas. So if you have employees who are citizens of Canada or Mexico, you can apply for a TN visa. This TN visa is pretty similar to a H1. There is a list of jobs which qualify, for example, engineers, accountants, scientists, medical professionals. There's no cap. You get it for 3 years at a time. Quick processing because you don't have to process at the USCIS level, you can go directly to the consulate or at the port of entry itself. But this is not available, of course, to Indian nationals. But if you are an employee and you have a Canadian or a Mexican national, it's applicable. Then the Australian, if you're an Australian citizen, you have something called the E3, which there is a quota of 10,500 visas, but the quota is never filled up. The criteria is same as a H1. It has to be a specialty occupation, meaning an occupation that requires a bachelor's degree in a specific field. You get it for 2 years, but it can be renewed indefinitely, and spouses also can work. So E3 is very good for Australian citizens. So there are a lot of Indian nationals who are also Australian citizens. Useful for them. Now let's talk about entrepreneur visas. So you are Indian entrepreneur. You want to set up your office in the US, and you want to come to the US for the purposes of setting up your office or doing a business in the US. Or maybe you already have a business in the US which you've been running from India, and now you want to move or travel frequently to the US. Sometimes, a B1 visa is a great option, but if you travel too frequently on a B1, they may stop you, and you cannot run your payroll from your US entity or get paid in the US if you're on a B1. That's a big problem for entrepreneurs. So the first option is the L1A, and we discussed this a little bit earlier. L1A entrepreneurs is pretty much very similar to L1A employees. It's the same criteria. You are a founder of a US company, and you also own the India company. You establish a new office in India. You expand your Indian operations to the US. The type of business doesn't really matter. You can do any business as long as it's similar to what you were doing in India. It can be any setup. It can be a INC, C Corp. Usually we suggest a C Corp. So that's a type of business. It can be a LLC, limited liability corporation. You can incorporate in any state, wherever my suggestion is to incorporate in the state where your clients are or where you plan to reside. But a lot of people like to incorporate in Texas and Delaware because there's no state taxes. But remember, then you have to run your business out of those states. And if you don't, you're just incorporating there, but you actually run business in some other state, then it makes no sense, because then you have to register in that new state wherever you're running your business and then pay taxes there. So it makes no sense to do that, to register in 2 states. If you are a new entity, then you require, and you're filing as a startup, then you require a business plan, a physical office. You have to show that you as the owner make all the executive or managerial decisions in the company. It is not presumed that simply because you are the owner that you are the executive of the company also. So you have to actually show that through documentary evidence. You have to show that you signed off on important documents. You have to show maybe you prepared the budget or signed off on the budget, for example, which is an executive decision. You have to show maybe minutes of meetings where you are, conducting an executive role, board meetings, for example. You have to show an org chart and show where you are placed in the org chart and who reports to you. You have to describe your duties, and the duties have to show that you do not actually do any duties that are, clerical in nature. Even if you do, your major duties are executive in nature. For example, I'll give you an example. Say you started up your business. You are the only person running your business. You have no other employees in the US to start off with. So you're taking care of everything: phone calls, accounting, administrative work. That's a problem. So at least hire one person to take care of that, and show a business plan that other people will be hired as well. in the future, and then you will get approved, otherwise you will not. As I said earlier, this is great for entrepreneurs because it leads to a green card very quickly. EB1C priority dates are in 2023, so that's pretty good. So within a few years, you should get your green card. There's no other avenue where you can get your green card so quickly, except if you are married to a US citizen. Then O1 works for founders as well. It's the same criteria, extraordinary ability. If the founder, you are an innovator, you've started up, made successfully, have many startups, you are a star, and you've made a lot of money, or you've started a business in India which has made a huge difference, and you can recreate the same thing in the US in certain fields, maybe healthcare, maybe education, maybe tech. So if you're able to show that, then you may qualify for an O1. You have to show awards, patents, funding, media, industry recognition, etc., etc. So O1 is great. It leads to, again, an EB1, extraordinary ability. It's flexible, unlimitedly renewable. There is no 6 years term or 3 years term to it. So that's great. That's why an O1 is good. EB5, green card. We're almost done, so please get ready with your questions. EB5, investor green card. This is well known, of course. So if you make an investment, you can either invest passively into a regional center, in which case 800,000 will be sufficient, or you can start your own business because you are an entrepreneur. Say you don't have a business in India, but you just want to start a business in the US. The L1 then will not work, and EB5 will work for you. EB5 is always, for me, a second option. L1 is always a better option because it's faster, it requires less investment. But if you don't qualify for L1, then EB5 is what you need to look into. Investment has to be 800 million to 1.05 million, 1.5 million. And if you're in an underserved area where the unemployment is high, then it's 800. Otherwise, or if you are investing into a regional center, that is as a passive investor, it's 800. Otherwise, it's 1 million. If you're running your own business and if your business is in a regular area, then that's the amount. To be eligible, you must create at least 10 full-time jobs, US jobs. You have to hire 10 US workers. You have to show where your source of funds came from. You cannot take a loan and show that. You have to show that it's not from any unlawful business. You have to show that it is tax-paid money. Again, you can either have your own business or you can invest in a regional center. What are the benefits? Permanent residency. You get a green card, you invest your money. So your money is working for you. Your spouses and children under 21 get the green card, you get the green card. You don't have to depend on any employer to sponsor you. While you're present in the US on a H1, say, you can file an EB5 by showing that you invested that 1 million into a business. Or if you're an O1, then you can file a EB5 as well. So it's not just for people outside the country, even people who are present in the country can show that they qualify for EB5. The next category is the gold card. This is a new category introduced by the present administration. This is for high-income entrepreneurs and executives who have substantial control in a US business. And you have to show that you have, it's kind of a combination of extraordinary ability, the O1 category, showing that you have extraordinary ability in the business field. And that's how you file it. You file it as a EB1 category, a green card category, so it's not current, mind you. EB1 is not current for Indian nationals. It's 2023, so it'll take a few years. But if you invest by contributing, this is just a straight contribution. You're not investing into your business. You're giving the US Treasury 1 million, and it's non-refundable, and they will allow you to file an extraordinary ability green card under the EB1 category. If you are a corporate or sponsoring for an employee, you're an employer sponsoring for an employee, then it's 2 million. If you're an individual, then it's 1 million. Processing fee is 15,000. Family members have to pay separately the 1 million amount. Benefits, self-sponsored green card. You get a self-sponsored green card under the EB1A category or EB2. NIW category, again, EB2 is really backlogged, so it's a waste. EB1A is not current, but it's a few years away from being current. Includes spouses and children under 21. Spouses can't be under 21, but children under 21. Flexible employment arrangements, no job creation required unlike the EB5. But I would rather, if I needed to get a green card, maybe I would just do the EB5. And even if I didn't want to do a business, I would do the regional center route as a passive investor in EB5. It's still less money and more likely to get in, because with the gold card, you don't know what the next government will do, whether they'll take it out or they'll keep it. And we've not received any approvals yet, or we have not done any gold cards yet. So it's a pretty new thing. I'm just concerned that you give the 1 million and then you still don't get the gold card, and there's nothing much you can do about it because it's not a tried and tested system and there's no regulation for it, and it's new basically. So that's why I'm a little hesitant to recommend the gold card. EB5 has been there for years. So if you're an entrepreneur in general, you have to choose the right strategy in order to decide which visa option to choose, whether you just want to stay here temporarily or you want to get a green card. Then if you want to stay here, if you want to get a green card, then you might want to use the L1 option, the O option. If you want to stay here temporarily, then there's one option which is not on the slide, which is the H1B option, self-petitioned H1B option. So for the H1B, they have a new self-petition option, meaning you can be the employer and the employee as well and sponsor yourself for a H1. But there are certain terms and conditions. You get it only for 2 years to start off with. You have to show that you have another partner or maybe a board of directors that has the right to hire and fire you. And based on that, then you can work for your own company. But then you don't get the green card, right? So that's why depending on your strategy, you decide on which one is better for you. You might start on an O1 and then file for an EB1 extraordinary ability. So you can even combine the non-immigrant and the immigrant petitions. L1, you start on an L1 and then you file for EB1C after 1 year. You can do it that way, or you can file, by the way, directly for a green card also, being an entrepreneur. File directly for a EB1C based on being an executive, or file directly for EB1A green card based on being a person of extraordinary ability. Of course, filing direct green cards means that you can't come in to the country immediately. It might take 2 or 3 years for you to come in, or maybe slightly longer. So again, your pathway depends on when you need to come in, how long you need to stay, and what are your future long-term goals. And also your business structure. So for example, if you don't have the business structure where you're able to file an L1, then EB5 makes more sense, right? So, yep. I think that's it. Now I will stop sharing my screen and we'll get into the Q&As. Right. Okay.
Thank you. Thank you, Prashanthi, for such an informative and very knowledgeable session. And and I think this is a very important subject which everybody wants so much information on this, and there's so many things that are going around, and people really need information. So we have some questions in the chat box, and I'll just read. So one question is from Vinayagam. My son holding H1B and his wife is completing her doctorate degree from Germany shortly. She wants to join him. What visa should she apply?
The best visa to apply would be a dependent visa, a H4, because that's the easiest visa to get even at the consulate. So she should apply for a H4. And then when she comes into the country, I mean, looks like she has a PhD, so she may qualify once she comes into the country for maybe an O1 or EB1 category, green card directly. So there are many options for her once she comes into the country. But in order to come in, I think the best option would be to file for a H4 dependent visa because that's the easiest and the fastest way for her to come in.
Right. Okay, this second question is from Sheetal. Hello, Ms. Reddy. I would appreciate your assessment of my situation and guidance on next. I am a CEO, owner of technology companies in India and the US. My L1A petition was approved by US CIS in November 2024. I appeared my visa interview at the US consulate in Hyderabad in June 2025. At the interview, my case was placed under INA 221G, administrative processing, medical evaluation via panel physician was requested, completed shortly after. Since then, my CEAC status has continuously refused, which I understand reflects pending 221G processing rather than a final denial. It has been it it has now been approximately 7 months with no further document requests. DS555 and no follow-up from the consulate. I don't know what to do. Please advise.
It's not unusual for administrative processing cases to take more than 6 months. Sometimes it even takes a year. So I would hang in there. I'm not sure what the issue is with the medical reports, but if that came out clear, and it's rather unusual for them actually to do um, the medical evaluation. Uh, I would be interested to know more, Sheetal, if you can text me as to what was the reason for them to do that, if you're okay texting with reference to that, putting it in the chat. But it is not unusual, as I said, for administrative processing, and you're right, it's not a denial. They are just looking into it further, they're doing further investigation. And if there were no other issues other than the medical issue, then if it comes through, then you should get the approval. As you know, now everything is at a standstill at the consulate, with all visas being postponed. And maybe that was another topic I should have talked about if I had time. But there is a huge standstill with reference to visas being issued. Uh, and even though India is not one of the banned countries, there are 39 countries banned, altogether like 70 something countries partially banned, and 39 countries fully banned from getting any visas. India is not part of that, but they have slowed down the visa processing in the consulates across India also. They have rescheduled most people's visa appointments. Everybody's visa appointments to 2027 based on they're saying that they need to evaluate further, look at people's social media, revamp the system, and then come back to issuing visas. That's the reason that they're giving. So it's not unusual. Just hang in there, and if the medical issue is resolved, then you should be able to get the visa approved.
Thank you, Prashanthi. So I request members that in case you have any other details to share one-to-one with Prashant instead of putting in the forum, public forum and all. So we'll be sharing the recording of this session, PPT, also the email ID of Prashanthi Reddy Garu. So please get in touch with her for any professional help, and you can talk to her regarding your issues. So the next question is Vinay Jain. Can one change current valid B1, B2 to L1A? Does it make sense for one who wishes to open a business in the US? Does L1A requires any visit invite, etc., like in B1 and B2? Please advise.
So, if you're on a B1, B2, if you have a B1, B2 visa, it depends on what you say by B1, B2. So, if you have a B1, B2 visa, but you're in India, then you, in order to travel to the US on an L1, you need to apply for a L1 visa. In order to apply for a L1 visa, you need to first get an L1 approval by filing an L1 petition with USCIS, with immigration. Then once they approve it, they send you an approval notice, I-797. And there's a lot of documentation that has to be submitted for an L1. As I said, you have to show that you're working as an executive. You have to show that you're both your businesses in India as well as in the US, you're doing business. So you have to show all your taxes. You have to show your invoices to show that you're doing business. Your bank statements. You have to show copies of your office leases. And you have to show that you're working in an executive position, prepare a proper job description, etc., etc. So it's a whole petition that you have to file, and not all L1s get approved. So it has to be filed carefully. There is premium processing available for L1. So once you get the L1 approved, then you go to the consulate with your L1 approval for an L1 visa. So that's how it works. And then once you get the L1 visa approved, then you travel with that visa to the US and you enter pretty much on an L1, and then you get an L1 I-94 stamped in your passport. And then you can be on the payroll of your company in the US. So that's how it works. You could also travel on your B1, B2, and then once you're in the US, file a change of status to an L1. In that case, you don't have to go for a visa immediately. You file a change of status. If the change of status gets approved, then you continue working or staying in the US on an L1. And then when you travel next to India, that's when you get your visa. You book an appointment and get a visa. So that's maybe now with the delays in visa issuance, that might be a better way of doing it if you already have a B1, B2 visa. But be aware that B1, B2 expires, so you have to file the L1 before the B1, B2 expires. So make sure that you have all the documentation ready maybe before you leave to the US.
Thank you. Mr. Vinay has added this his whole query one more line in the next question. If L1A taken, what kind of visa can the spouse get?
The spouse gets an L2 visa, and that's really good because it allows the
Right.
L2 allows you to work. You don't need any separate work authorization. So now both you and your spouse can work in the same company. Your spouse can work anywhere. She can work even in a gas station or in McDonald's, doesn't matter. So that's the advantage of the L2 dependent. They can work anywhere. It's not like a H1 where they have to work for the employer that filed the H1. And they don't need a separate, to file a separate petition. They're automatically eligible to work. So that's really great to be an L2 spouse.
Okay, thank you. So the next question is by Mr. Sandeep. Regional center project returns are how much minimum?
So usually regional centers don't give great returns. They'll give some interest rate of maybe, very low interest rate. As it is, the interest rates in the US are very low, right? Even for your bank or whatever. They might give a 0.1 interest rate, or they might not even give any interest rate. They might not even give any. So it depends on the regional center, but they usually give a very low interest rate. The benefit that they are giving you is the green card. That's how they look at it. And of course,
Okay.
please do your due diligence when you choose a regional center, because there are a lot of scams also out there. They take your money and run away. So make sure
Right.
you've done your due diligence.
Right. The next question is by Mr. Ravindran. if I get an L1 visa as an entrepreneur, do I need to live in the US to apply for a green card?
Not necessarily, but you have to show. Well, if you're applying for an L1, what is the purpose of applying for an L1 if you do not want to live in the US, right? The purpose of an L1 is that you live and work in the US. That doesn't mean that you cannot travel back and forth. You can on an L1 travel back and forth as required, for your business. But you have to show that you're living at least 6 months in the year in the US. Otherwise, there's no purpose of the L1. Now, if you just want to apply for a green card without applying for an L1, you can do that as well. As I said, apply directly for a green card from India. Um, you know, but if you want to apply for a green card from the US, which is by filing adjustment of status, which is faster, then you have to show that you're living in India. You have to show that you're living in the US, and you have to show that you've established residence in the US by showing, residence at least 6 months in a year.
Okay. The next question is by Mr. David. I'm an Indian entrepreneur. If I choose EB5, will my income earned in India be taxed under American law?
So worldwide income, this is again a tax issue, and I'm not an expert, but whatever I know, I'll let you know. Worldwide income is taxed in the US. So anyone who files a tax return in the US, whether you're a citizen or not a citizen, you have to pay income tax on your worldwide income. So if you're already paying taxes in India, for example, then you don't have to. There's no double taxation. But if the tax bracket is different, then you might have to pay the remaining tax.
Okay. The next question is by Soma. My son is a co-founder of a Delaware C corporation. What is the visa he can apply for? He can apply to work in US.
Uh, like I said, there's several options available for him. If he has a company in India, then he can apply for an L1. If he doesn't have a company in India and only has a company in Delaware, then he can apply maybe for a self-sponsor H1, or he can apply for a O1 category as a business owner, or he can. I guess those are the two options that he has, or he can file directly for a green card as a EB1 if he qualifies.
Right. Next is by Mr. Jagannathan.
Sorry,
Does US
sorry, Shika. Also, he can apply for EB5 because he's invested money
yeah.
into that corporation.
Right. The next question is by Mr. Jagannathan. Does USD 1 lakh apply for those who worked in the US on H1B or L1 before and returned?
Yes,
Should I
it
read
does.
again?
No, I understood. So he's asking the 100,000 fee, does it apply for people who worked in the US on H1B or L1 before? Earlier they worked on a H1 or L1 and then returned to India. Now they're staying in India. It does apply to them because when you're filing the H1, well, it depends. If the H1 is still valid, and they are just applying for a visa, the visa is expired, or the visa is not expired, H1 is not expired, and they're just traveling, then it doesn't apply to them. But if their H1 has expired and they're applying for a new visa now, and if they're applying for a new visa now, they'll have to apply for consular processing because they cannot, it's not an extension because they're not in the US. Then it does apply to them. So it depends on whether the H&L is expired or it's still valid. If it's valid, they can use the same to come back into the country and they will not be charged. But if they're filing for a new H1, then they will be charged the 100,000 fee.
Okay. Mr. has asked a question. H1B filed in 2024 and the visa refused in 2020 may due to RFE from employer point of view. If a new year wants to transfer this, will it require $1 lakh fee?
I am not. Where is Mr. Shah's question? I don't see it. But if you can read it again because I don't see it.
Yeah, sure. H1B filed in 2024 and the visa refused in 2025 may due
I see
to
it. I see.
RFE from employer
RFE.
point of view. If a
Okay.
new employer wants to transfer this, will require $1 lakh fee?
Okay. So basically, the scenario he's talking about is H1B was previously filed, it got approved, but the visa got denied, and so the person couldn't come into the country. Made due to RFE from employer. Okay. So now, if a new employer wants to file for a H1 for him, does the 100,000 fee apply? Unfortunately, it does apply. Though it's cap exempt, you're filing consular processing. If the person is outside the country, and you have to file consular processing. You cannot file extension, amendment, transfer. If you're filing consular processing, automatically the 100K applies. So in your case, yes, the 100K does apply.
So next, Prajakta, she mentioned it was nice, very nice and informative session. Thank you. Thank you, Prajakta. Mr. Vinay again has sent a question for startup in the US. So obviously there will be some different rules, but I think it will take, is there,
Yeah. So
we
startup in
can
the US
speed.
is on a L. If you are
Okay.
filing an L1A for a startup in the US, then as I said, the rules are a little different. You get the L1 for 2 years, and you have to show your business plan. You don't have to show that you have any tax returns because you won't. You don't have to show that you're actively doing business in the US because it's a startup. You have to show you have a bank statement, you have some kind of funding in that to help your startup in the beginning, startup funding. You have to show that you have an office space. Then you have to show you have a business plan and how what your revenues are going to be for the next 5 years, how many people you plan to hire, etc., etc. So as long as you're able to convince them of that, show a org chart of your future org chart, show job description, show that you've hired at least one person. I would say don't have zero employees even for a startup. Show that you've hired one person and that one person can do the administrative work, because they don't want you to be doing the administrative and the clerical kind of work, right? L1 is not supposed to do that. So as long as you're able to do all those things, you can definitely get on an L1 for a startup.
Okay. The next question, I have L1 visa valid for 3 years from September 20. Can I travel anytime before 3 years? And if yes, how long can I work?
Yes, if you have a L1 visa valid, you can travel before the visa expires. If you haven't traveled since 2024, at the port of entry, they might ask you why you haven't traveled. So you have to give an explanation that something changed or something didn't happen and now it's happened and therefore I'm traveling. Give some explanation as to why there was a delay in travel. You can stay for the remaining period of your L1, whatever that period is. The L1 period is determined by the I-797 approval, and then they'll look at the I-797 at the port of entry and give you an I-94 for the period of that approval. Then you can file an extension. So you can continue to stay in the US on an L1 for, if it's L1A, for a period of 7 years, if you have not filed a green card. If it's L1B, then a period of 5 years.
Okay. Next question, Dr. Bhaskara. Please send the recording to the Mr. Dr. Bhaskara, you have registered on our link and we have your email ID, you will get the recording. Otherwise, you can send me an email. Here, I cannot note. Sorry for that. And again, then you mentioned change of status while being in the US is easier for say B1 to L1. May I know what the procedure would be?
Would be.
Should I
Uh,
read again?
no, I got it. So they're
Okay.
saying that the change of status procedure, what is the procedure for change of status from B1 to L1? So it's the same process. You have to file, instead of filing L1 for consular processing, you have to file L1 change of status. So in the form, you just have to mark it as change of status. So the procedure is not very different. In the form, you just have to mark it as such. So the process is the same. You have to, of course, show that you are in status on a B1. and that is you have to put in your I-94, your B1 I-94 and your passport, and they should approve the change of status as long as you're in valid B1 status.
Okay. Next question is, can a person directly without employer apply under extraordinary ability or innovator? Person from India.
Yes, you can apply for EB1 extraordinary ability green card. If you are extraordinary in whatever field, technology, innovator, arts, sciences, whatever it might be. Now you have to in order to do this, you have to file an I-140. Once the I-140 gets approved, then it is consular processing. So it takes a few years for sure, because priority dates are not available. EB1, though EB1A is 2023, but still it's not current. So it might take a few years to become current. And then the processing time itself for a consular processing green card to get approved takes 1 or 2 years. So it can take 3, 4 years, 4, 5 years for it to get approved for the entire process. Maybe not 4, 5, maybe 2 or 3 years to get approved, but it's possible, yes.
Okay.
On an O1, on the other hand, without an employer, you can file an O1, but O1 generally you have to show that a company is sponsoring you. So without an employer, an O1, though it's the same innovator kind of visa, that I would get an employer to sponsor me, because you can't self-sponsor on an O1.
Right. Thank you. So I think we have completed all the questions. So it's now time for the vote of thanks. I, on behalf of Indo-American